We'll call your case when this well's cleared. Next case to be heard is Auman versus Leverock Seafood House.
May it please the court. My name is Bill McCabe. I represent the claimant, Kathleen Auman. This case is a little bit unusual, so I'm going to just briefly go through the facts of the arguments a little bit more in perspective. In this case, the claimant had 3 compensable accidents with the same employer, but only 2 matter for this appeal. First one occurred on October 17, 2004, when she injured her knees. Right after that accident, she went back to work. The second accident that matters occurred on October 27, 2004, when she injured her right elbow. She hasn't been back to work since. Now, the judge found that the claimant has been continuously temporarily disabled from her October 27, 2004 right elbow injury since it happened.
How about the other injury? Did he find that there'd been a disability during that same period for that same injury?
Well, the second injury, or the knee injury, the judge found that she was continuously temporarily disabled since January 12, 2005, because that's when the doctor first put her on disability for the knees.
Well, are you saying that she got 2 compensable injuries here, and she's got a bank, and there's 104 weeks on this one, there's 104 weeks on that one, and she can draw on one even though she's disabled on the other, and that keeps the other part in the bank, so to speak? I know that's rough. Is that what
That's exactly what the argument is. The argument is that she has a bank, if you will, of 104 weeks of temporary disability benefits for the October 27, 2004 right elbow injury, and she has a bank of 104 weeks of temporary disability benefits for the October 17, 2004 knee injury, because these are separate accidents, separate injuries.
But the statute in question talks about disability, not accidents or injuries.
Well,
440.15.2 talks about disability. It doesn't talk about disability for separate accidents or disability for separate injuries. It talks about temporary total disability, doesn't it?
yes, and it says, shall be paid during the continuance of such disability not to exceed 104 weeks. And then if you look at the definition of disability, it's incapacity because of the injury to earn in the same or any other employment.
Do you think that the legislature contemplated this problem when it drafted the statute?
Probably not. I mean,
if they had, how do you think they'd have resolved it?
exactly as we're arguing.
Okay.
Because
we must have different views regarding our legislature then.
well, here's what I think the judge's error is. I mean, the judge found that she is entitled to more than 104 weeks of temporary disability. But what the judge did is the judge says, okay, she was temporarily disabled for the knees since January 12, 2005. So I'm going to say that our 104 weeks for that injury ran from January 12, 2005, and I'll give her temporary disability until January 12, 2007.
That's just the way that Buddy Freddy case says not to do it.
Exactly. There's 2 cases, the Buddy Freddy, Cooper versus Buddy Freddy's Restaurant, and then the original one, which is Wright versus City of Rockledge, that says the claimant's 104-week limit to eligibility for temporary disability is measured in terms of cumulative payments received rather than consecutive weeks. Now, the judge made a specific finding that the 104 weeks of temporary disability that the carrier agreed to pay the claimant was for the right elbow injury. She got 104 weeks temporary disability from October 27, 2004 to October 26, 2006 for the right elbow. So there's her 104 weeks are gone there. She hasn't used any from her bank of her knee injury as of October 26.
But she was receiving temporary total disability benefits during the period she was disabled from both injuries.
But she was receiving it, and the judge made a specific finding both in his final judgment and orally stated it in the motion for rehearing that the 104 weeks she got was for the right elbow. It wasn't for the knee. She hasn't used any of her knee yet. Now, the judge gave her 11 weeks.
What if you had an injury what if you had an accident where your leg was broken and the arm was broken? Could you say, and you have disability in both? I'm getting 104 weeks from my arm, and I'm getting 104 weeks from my leg, and that's 208 in my bank.
If it's the same date of accident, that to me is the key. If it's the same date of accident, she could injure her back, her arm, her knee, her shoulder. Doesn't matter. She gets 104 weeks of temporary disability. But if it's for two separate, distinct accidents.
What if he breaks a leg at work, they take it on the way to the hospital, and somebody runs into the ambulance and breaks the arm? That's the same day.
Well, it's all still, that would be compensable because you got injured on your way for treatment for
you get 104 in each instance that's there. Then.
No, because the only reason her accident is compensable going to the hospital is because she's going there because of her original compensable accident.
Mr. McKay, let me take you back to Judge Webster's question about legislative intent. What is the intent behind the 104-week cap?
Well, if I had to guess, it's that the legislature presumes that 104 weeks is enough time for somebody to be healed. I mean, otherwise, what's the reason for arbitrarily saying you can't get temporary disability for any more than 104 weeks? Now, in this case, that's not what happened.
But that rationale would support your position, right? Because the healing we're talking about, in this case, has to take place from two distinct injuries sustained in two distinct industrial accidents.
Yes, it does. But, again, I mean, let's assume this lady was temporarily disabled for 4 years from a particular accident. She could actually select which 104 weeks out of those 4 years she wanted to use her temporary disability, I would think. I mean, there's no rule that says you got to use it from the first day you become disabled. I mean, you might have a situation where somebody's temporarily partially disabled and they make pretty close to their average weekly wage for part of the period and not pretty close for another part. Well, they're going to maybe select that other part to get their temporary disability.
Isn't the presumption that appears to be included in the statute to the effect that if you're after 104 weeks, you're still totally disabled, you need to be looking for permanent total disability benefits?
Yeah, but the problem with that is, I mean, in this case, this lady didn't get medical treatment. That's the reason why there was apparently some confusion over which insurance company was involved or what have you. But this lady, so you can't go to a doctor, you can't get permanent total disability before you reach maximum medical improvement unless you have a doctor that says, well, when you reach maximum medical improvement, your limitations and restrictions are going to be X, Y, and Z, and then you can establish that that would make you permanently totally disabled. Well, doctors don't guess. A lot of times this lady hasn't even had her surgery yet. She hasn't had her right elbow surgery. She hasn't had her knee surgeries.
But if you've used up your full 104 weeks, it doesn't matter whether you've reached maximum medical improvement or not, does it?
No, it doesn't, but you can't get permanent total disability until you have a doctor come in and say when you do reach MMI, you're still going to be totally disabled, basically. And they don't have that here. But But there's not a single case that supports the judge's ruling or their argument. There's not a single statute that supports the judge's ruling or their argument. They're not there. Let's suppose this lady had two separate employers. Let's suppose she injured her knees on October 17th, and then she went to a second, totally different employer, and unfortunately got injured on October 27th and injured her elbow. There would be no question that she's entitled to 104 weeks disability for each accident.
But how about when you're disabled during the same period and you're getting your average weekly wage paid?
Because
wouldn't that be a charge against both?
No, it's a charge against the elbow injury. That's what the judge specifically found. The elbow, October 27th injury, the 104 weeks is gone. What has been taken for the knee injury during that period when she was getting the disability? Nothing. Nothing. She still has her 104-week bank.
What if the judge would have said that made a finding that both injuries there, rather than just as to the elbow, said from the knee and the elbow, would that have hit your bank twice?
Well, that's an interesting question, but he didn't make that finding.
Well, I'm just probing a little bit here.
That's an interesting question.
Your argument would be substantially weaker, I presume.
Pardon me?
If that were the case, your argument would be substantially weaker, would it not, if he made a finding as to both?
Well,
I mean, the consequences of a disability, one disability, is what's addressed in the statute, isn't it?
Right, but it's for each accident. And, there's no case on this. I mean, this is kind of an unusual situation.
I know.
I likened it to a fraud case that we had here once, and I think it's Paulson that I cited in my brief, where this court found that if you lie about accident A, it doesn't keep you from getting benefits in accident B. And kind of by the same rationale, if you get temporary disability benefits for accident A, it shouldn't keep you from getting additional temporary disability benefits for accident B. So I guess I'll...
You're saying since the JCC found that there was a specific injury that was going after, that doesn't affect the other? I mean, the elbow. That's all that is charged to, and you still got the other 104.
And the judge made it clear that the temporary disability that this woman got was strictly on the right elbow injury.
Mr. McCabe, before you sit down, I want to ask you about Cooper and Wright. I think you can see that neither of those cases is directly on point. All they stand for is the proposition that you're entitled to a total of 104 weeks, and that it doesn't have to be the first 104 weeks after your accident. Isn't that all they stand for?
Well, yes, it stands for that it's not it's not a consecutive 104 weeks, but that's
it's a cumulative 100.
Right.
How does that, I'm still not sure I understand how that supports your argument in this case.
Because what the judge apparently did in this case is he said that she became temporarily totally disabled on January 12, 2005 from the knee injury. So I'm going to give her temporary total disability until January 12, 2007.
But didn't he give her a cumulative total of 104 weeks for each disability? It just happens that two of them ran during part of the same period.
Well, she wasn't paid any temporary disability.
But he gave her a cumulative total of 104 for each one.
Well, he did find, I guess you could look at it that way, but the problem with that
is that she didn't get paid for both of them.
Correct.
I understand that's your point.
Correct. Thank you.
May it please the court, my name is Bill Rogner, and I represent the employer carrier in this case. Judge Browning, you summarized 100 pages of brief in a single sentence. That's exactly what this case is about. The parties agree. She was on a TTD status for her arm from January 12, 2005 to October 27, 2006. The parties agree. She was on a TTD status for her knees from January 12, 2005 to October 27, 2006. The parties agree that she was paid total disability benefits for that entire period of time.
For 104 weeks for the first injury.
Correct.
And she was entitled to a total of 104 weeks for the second injury.
Right, and because after October 27, 2006, there were still 11 weeks remaining on the knees, the judge ordered us to pay that, okay? So, Judge Webster, you cited exactly the right statutory language. Under 440.15.2a, it doesn't say that you get disability for each accident or each injury or anything like that. It says you get, for disability total in character, you get paid temporary total disability benefits. That's what she got. She got it. She was paid by this employer for that disability, for every week that they're asking her to be paid. What they want to do is they want to say, well, wait a second. The way we look at this case, and absolutely no statutory or case law support for it, but the way we look at it, claimant says, is I got a bank account, a checking account, when I hurt my arm, and I got another one when I hurt my knees. And despite the fact that you're paying me while I'm on TTD status for both, I choose to tick it off of one claim so that I can leave it open on the other claim. There's absolutely no support in any statute or any case for that type of analysis.
What is your position on the hypothetical that was posed where somebody is making almost what they made before the accident for a period after the accident and does not want to take TPD payments for that period, but later loses that employment and wants TTD?
Judge, I'm not sure I really understand the nature of it. I'll give it a shot. All we're saying, and all we've said from the beginning, is you can get 104 weeks of disability, temporary disability for your accident.
And you agree they don't have to be the 104 consecutive weeks immediately following the accident?
Absolutely. I concede that's true because you told us that's true in the Cooper case and the Wright case.
So you might say it comes down to who gets to choose, the claimant or the EC?
No, I don't see it that way at all, Judge, because we didn't make a choice. She was paid. She has been paid for each and every one of those weeks she was disabled. She's been paid by my employer. She was paid for every week between January 12, 2005 and October 27, 2006, while she was on a TTD status for her arm.
At her request, I take it.
She asked for it. She wanted the benefits, and we paid them to her. It just so happens that you have two doctors treating her. One says, I think she's on a TTD status for her arm. Great, here's your check. The other one says, I think she's on a TTD status for her knees. Great, you get a check. Do you get two? Of course not. Judge, you've told us in a permanent total disability situation. Now think about this. Total disability. The only distinction in this case is whether it's temporary or permanent. But you've told us, here's how we deal with this in a permanent total disability setting. It doesn't matter whether you've had one injury or 9. You get one check because you're being compensated for disability, total, and character.
So even if you could have been in a PTD situation, you had multiple injuries and you'd be PTD as a result of each injury.
Right. You
still only get one check.
Absolutely, and it doesn't somehow not count, against these other cases. I mean, it still counts. Now, another question that was asked earlier is, or maybe it was a point made by Mr. McCabe, is, there's no question that if she would have been hurt on a Tuesday working for one employer and hurt on a Thursday working for another, she would definitely get 2 banks. Completely disagree. Completely disagree. She gets paid for disability, total, and character. Now, what happens? We have 2 employers. We have 2 carriers. What do? Well, we go to 440.42. Tells us exactly what we do. The judge assigns blame between the carriers.
But she still only gets 104 weeks.
That's all she gets. She gets 104 weeks. Now, maybe my client has to pay 50% of it, and they pay 50, or maybe I pay 30 and they pay 70, because that's a dispute between the carriers as to who pays for the disability, total, and character. Disability, total, and character, you get one check. Now,
what do you understand the legislative intent to be in enacting the 104-week cap?
Well, I've been doing this for 18 years. And so I've seen a lot of the changes. And I think, Judge Browning, you sort of hinted a little bit about what I think we all know that the legislature intended with each of these changes, particularly starting in 1990. And that was to reduce the benefits paid, to reduce the total amount of compensation that is paid out, because we used to have very lengthy caps on temporary benefits, and they were greatly shortened. We used to have hourly fees, which were eliminated. We used to have all kinds of things, unlimited chiropractic care, which was eliminated, unlimited impairment ratings for psychiatric cases, which were eliminated. Each of these changes was intended to reduce the burden on industry and to make these cases, as the legislature has clearly stated, move at a more rapid pace. We want a rapid provision of benefits. We want to get the injured worker back working again. And so there's certainly no legislative intent that I can possibly imagine that they would have intended the statute to be interpreted in the way that Mr. McCabe wants it to be interpreted. So I think that our position clearly supports the legislative intent, which was to reduce and not increase benefits. Here's how this kind of works in practice. We often have two injuries. It's not uncommon to have a claimant with two injuries. And the claimant is entitled to a separate menu of benefits, so to speak, only where those benefits are clearly separable. So, for example, in our case, the claimant would be entitled to an IME at her expense for her knee claim, and she would be entitled, assuming she could make the evidentiary showing, to an IME for her arm claim. So that's two different IMEs. Statute says you get one, she would get two in that case. Okay? But let's assume that both her doctors prescribed narcotic pain medication. Does she get double the narcotic pain medication? Does she get to double up on narcotics? Of course not. Of course not. What if she needed a 24-hour a day of attended care? Does she get 48 hours a day of attended care? Of course not. She only gets what she's entitled to, which is exactly what she got in this case. She got exactly what she's entitled to in this case, short the 11 weeks that the judge ordered us to pay her. So if you look at paragraph 15 of the order, it really sort of belies the entire argument that they're making, that the judge found that her disability was just related to the arm. That's what she got paid for, just the arm. Well, we wouldn't have this case if that's what the judge found. The judge found that I find that there was a concurrent period of disability, that she was disabled by both injuries, according to the doctors, for this fixed period of time. And therefore, it applies against both injuries. It makes perfect logical sense. There's no statute that says the judge is wrong. There's certainly no case that says the judge is wrong. And I think that our position...
Well, you agree that it's an open question. There's no statute or case that establishes your position either.
Well, I think the statute establishes my position. I agree that it doesn't say, and by the way, if the claimant gets hurt twice with the same employer, she only gets one check during her period of total disability. I agree it doesn't say that. But it says that the claimant gets paid 66 2/3% of her average weekly wage for disability, total, and character.
All right, so under your view, if the claimant had been injured a second time at the 102-week point, then she would have been entitled to an additional 102 weeks.
Yeah, because assuming she was still disabled, she ran out 2 weeks later for the first one, she'd have 102 left. Look, we're not saying, I want to be clear.
Now, again, if you tie this back to what is the legislative rationale there?
Well, Judge, I think what you alluded to with Mr. McCabe is you said, well, wait a second, aren't they supposed to have this period of time to get better? Well, this lady, her two accidents were 10 days apart. I think it was 10 days, roughly 10 days apart. She was paid 2 years of disability benefits after the second accident. She was paid for 2 years after the second accident.
Aren't you going back to the calendar, not bank model?
No, I'm not saying that she lost because of the calendar. I'm saying she lost because she got paid. She got the money.
She asked to be paid.
She asked to be paid. She rewrote the checks. She cashed the checks. So she was paid. She's not penalized at all. Judge, let me say it this way.
Now, what request did she make on or after January the 12th, 2005?
To be paid temporary total disability benefits. That's what she wanted. That's what she got. And we went to trial over whether she got more, and she won. She got 11 more. She got 11 more.
All right, so she has to, what does she do? She has to file weekly forms? How does that work?
No, with temporary total, that's where the doctor says claim it's off work, and the checks go automatically. There's no...
My question to you was, what request did she make?
The petition for benefits that's in the file, and I don't know the date of it offhand. Mr. McCabe will probably have that by the time he gets back up here. But her claim is for temporary total. But, Judge, remember, it's a self-executing system. She gets the benefits to which she is entitled, presumably automatically, and that's what she got. She got paid the disability benefits to which she was entitled.
Well, that's by virtue of the original elbow injury, and that's clear from the records of the adjuster.
Well, Judge, that is true, that it was paid on a payout ledger that referenced one date of accident because, trust me, I've been doing this a long time. If you have 2 dates of accident, you have to set up 2 different files. The state requires that. But the question is, what has she been paid? She has been paid temporary total disability benefits for each and every one of these weeks at issue.
Well, I understand that position, but I did not understand your assertion just now that she asked to be paid on account of the knee injury.
Judge, maybe we're misunderstanding each other, but with all due respect, we're here because that's what she's asking. She's asking to be paid again for the same disability. I understand that perhaps you and I have a different way of looking at that particular issue, but she has been paid for all of the weeks at issue. They simply want to say that it doesn't count. It somehow doesn't count.
Toward the second one.
Correct. That's really, I mean, it was summarized, Judge Browning, in the first minute of this oral argument when you said, isn't this what we're really talking about? Does she get to sort of just check it off on one side and leave it off the other ledger? Now, Judge Benton, look, if she had never been disabled at all for those knees, never been disabled at all, she was disabled for the arm and the 104 weeks runs out. And then 2 weeks later, the doctor says, oh my goodness, we've tried for 2 years to treat these knees. I've decided I need to do surgery. She's on a temporary total disability status. She'd get paid. She'd get paid. There's no question she'd get paid.
She wasn't disabled during the period you were paying.
Exactly.
Okay.
She was disabled for the other claim, okay? But in my case, it's completely different. She was disabled for both at the same time. The only question...
There's a merger there is what you said, and the one disability and that's the payment.
You know, I never thought about using the term merger, but basically, yes. We have a lady who works here. She hurts one body part. She hurts the other. The doctors say, you're off work for these 2 body parts. Here's your check. Here's your check. Here's your check. And that's all she gets. And there's absolutely nothing, and Judge, I totally concede there's no case that says I'm right. There's no case that says I'm right. But I think that our interpretation is consistent with both the statutory language, which focuses on disability total and character, and being paid 66 2/3%, and it is more consistent as well with the legislative intent.
Which you see as simply being minimizing the costs to industry.
Well, no, I'm not saying that, because the other intent, and it's clearly stated in the statement of legislative intent, is that they wanted to encourage the rapid provision of benefits and the rapid return to the workforce of the injured worker, as opposed to the way we used to have it, where, I mean...
That would militate in favor of a construction like the one rejected in Buddy Freddy.
The bank versus calendar months. Well, I agree. I mean, honestly, when that law came out in 1994, and you interpreted the law that way, I thought you got it wrong. But it doesn't matter now because that's the law. But that's not what we're talking about here.
Well, I understand that. But given those decisions, then the rationale would be that the bank has not been exhausted on this discrete industrial accident.
Judge, I realize that you and I appear to be going round and round on this, because I could not disagree more strongly, because she was paid She was paid for those weeks.
Your position is Wright and what is the other one, Cooper? They don't have anything to tell us about the outcome in this case.
Completely irrelevant. And Judge, I'm out of time. Thank you very much.
Okay.
To answer your question, Judge Benton, it looks like at least as of September 27, 2005, maybe earlier, she was asking for temporary disability benefits because of her knees also. However, she didn't get any temporary disability benefits. She might have gotten a few weeks, but they did a stipulation in November of 2006 when the carrier agreed to pay her the 104 weeks of temporary disability. So when she filed it, she wasn't getting any. When she was asking for temporary disability for her knees, apparently at that point she wasn't getting any from either accident. It was after that that they stipulated the 104 weeks, which the judge specifically found. And I want to he specifically found it was paid for the October 27th elbow injury. It's on page 367 of the record, paragraph 6. And it's also on page 433 of the motion for rehearing, where the judge says he made it clear that the whole 104 weeks was for the right elbow. I think the statute also helps our position. The statute says temporary benefits shall be paid, the temporary total or temporary partial statute says temporary benefits shall be paid during the continuance of such disability not to exceed 104 weeks. 440.02.13 defines disability as incapacity because of the injury to earn in the same or any other employment, etc.
But it's undisputed, Mr. McCabe, that the JCC awarded her 104 weeks for each disability. Unfortunately, in your client's case, the periods of disability overlap.
She was paid for the injury. She was paid 104 weeks for the...
The statute says nothing about injuries. It talks about disability.
But disability defines, 440.02.13 defines disability as incapacity because of the injury.
And she got 104 weeks for each disability.
No, she got 104 weeks for the right elbow, and that's the judge's finding on paragraph 6. That's what the judge finds. He doesn't say it was for both. He says, I find, the undersigned finds that the accident of October 27, 2004 resulted in injuries to the claimant's right arm and elbow, and she has remained temporarily disabled as a result of those injuries since that date. Based on the joint stipulation, it is clear the parties intend the entire 104-week period of temporary benefits authorized by law should be paid for the disability sustained by the claimant in that accident, October 27, 2004. Again, my position is real simple. This lady had two separate and distinct accidents. One resulting
in a disability that occurred at the same time for both of the accidents, right?
Actually, the knee disability occurred a little bit later, but yes, she had, 93 consecutive weeks where she was temporarily disabled.
Slight overlap. And is anything disputed in this record that they didn't have 2 periods of disability, at least for that overlap period? Do you agree to that, Mr. McKay? You had, for both injuries, you had a period of disability, and they overlapped 93 weeks.
Yes, I agree with that.
You agree with that? That's not in dispute below.
No, sir, it's not.
And as far as we know, on this record, the disabilities continue.
They do continue. She still hasn't had the surgeries.
And we don't know when either will end.
That is correct.
Mr. McCabe, if we follow the logic of your reasoning to its conclusion, it strikes me that if your client said, I want 2 checks each week, one for this disability and one for this disability, rather than having 208 weeks, I want to get 2 checks for 104 weeks, they'd have to give them to her, wouldn't they?
Well,
I mean, what's the difference? If she's entitled to a bank and she wants to get both checks for 104 weeks rather than one check for 208 weeks, why isn't she entitled to that?
Because you can only get 66 2/3% of your average weekly wage for temporary total disability.
But you're arguing per disability. You're arguing per injury.
Right. But,
Okay.
I'm sorry, I didn't mean to interrupt you.
No, it just strikes me the logic of your argument ultimately is if she says, I want two checks for 104 weeks, she's entitled to them.
Well, I mean, I see where you're coming from. But to me, she gets 104 weeks for injury A, or accident A, and she gets 104 weeks for accident B. She's used her 104 weeks for accident A. She hasn't used her 104 weeks for accident B.
What would the situation be if at the end of this 104-week period for which she was receiving benefits, the second injury had resolved?
Then she wouldn't be entitled to any benefits because she's no longer disabled.
But she had 100 weeks, roughly, or 98 weeks or whatever it was, when she had disabilities from two injuries. The logic of your argument suggests she should get another 98 weeks of checks even though she's no longer disabled from that injury.
No, she shouldn't. But she does in this case because she is still disabled from that injury. She is still temporarily totally disabled from the knee injury, and she has not been paid benefits for that. Now, the real way to solve this problem is let her undertake the surgery that the doctors recommended 2 years earlier, and then we wouldn't even be in this situation. But unfortunately, that didn't occur. Thank you very much.
That concludes our calendar for today in court being recessed.